All right, we're back on the record, and Mr. Stribic, in all candor, I wanted to talk to the attorney and the prosecutor at the bench because the plea agreement calls for a sentence agreement at the low end of the guidelines, and I needed some explanation to understand why that should be what I do in this case. And they reminded me of some of the facts leading to this violation that were misdemeanor in nature. So we're going to go forward with that. Okay.
Appreciate it.
All right. So Mr. Spencer, for purposes of arraignment, do you or your client wish to do you agree to the filing of the amended information for
Yes,
purposes of plea taking? Do you or your client wish to have those allegations formally read?
No, Judge.
And is a forensic center referral requested?
No.
Okay. All right, Mr. Stribic, would you please raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, Mr. Stribic, you can put your hand down. If you have a question, go ahead and ask me. If you need to talk to your attorney, as I said, just let me know. The charge in the new file, possession methamphetamine, is a felony punishable by up to 10 years and or $15,000 fine. And larceny less than $200 is a misdemeanor punishable by 93 days and or a $500 fine or 3 times the value. Do you understand the maximum penalty?
Yes, I do.
And in these other 3 probation files, you're on probation to me for possession methamphetamine habitual 4th, delivery methamphetamine habitual 4th, delivery methamphetamine habitual 4th. With the habitual tales, they all involve life maximums. Your guidelines in those files are 10 to 46 months, 72 to 240 months, and 72 to 240 months. If I find you to be in violation of your probation, you could be sentenced to on those charges. Do you understand the maximum in those charges?
Yes, I do.
And you have the right to have a trial in the new case and a probation violation in the old cases. At that trial, you'd have the right to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. You would have the right to have the witnesses against you appear and to question them. You'd have the right to present witnesses in your own defense and have me order them to show up. You'd have the right to testify in your own defense or remain silent and not have your silence used against you. Do you understand those rights?
Yes, I do.
In the probation matter, you have the right to have a contested hearing where the violation will need to be proven by a preponderance of the evidence and the assistance of an attorney, the right to present evidence in your own defense and present questions to any of the witnesses presented against you. Do you understand those rights?
Yes, I do.
All right. And do you understand if you plead guilty, you won't have a trial and you'll be giving up those rights?
Yes.
Is that what you wish to do today?
Yes, Your Honor.
All right. Do you understand if you plead guilty, you also give up any claim that this promise was caused by threats or that this plea was caused by any threats or by promises beyond what's placed on the record? Do you understand that?
Yes, I do.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission by filing an application. Do you understand that?
Yes.
All right. The plea agreement provides an exchange for your plea to the possession of methamphetamine and the misdemeanor larceny in the new file, and thereby admit that that violated your probation. The prosecutor will dismiss the drug doubles and the habitual 4th in the new file, and there's a sentence agreement that there'd be a cap on any of the sentencing of 72 months in all these files, and that they would be concurrent with each other and also with the Emmett County sentence. Do you understand the terms of that plea agreement, Mr. Stribic?
Yes, I do.
That sentence agreement is not binding on me. If I didn't want to follow it at the time of sentencing, I wouldn't have to. But if I didn't follow it, you'd be allowed to withdraw your plea. Do you understand that?
Yes.
Now, that's unless you engage in some misconduct between now and the sentencing. Let's say you commit an offense while you're inside. That happens from time to time. Then we show up for the sentencing. Then by your own misconduct, you would lose the right to withdraw the plea, even if I wanted to go above that sentence agreement. Do you understand that?
Yes, I do.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty today?
No,
Has anybody threatened you?
no,
Is it your own free choice to enter this plea?
yes,
Knowing all this, how do you wish to plead to the charge in 7137 of possession of methamphetamine?
guilty.
And how do you wish to plead to the charge of misdemeanor larceny less than $200?
Guilty.
So, Mr. Stribic, back on October 20th of 2025, were you in Sheboygan County?
Yes,
And did you come to have in your possession prescription medication belonging to another person other than you?
yes,
And without that person's permission, did you steal some of that prescription for your own use?
yes,
Okay, I mean, did you take the prescription that belonged to somebody
Yes.
else? Okay.
yes,
Okay, and did he give you permission to take it?
no,
And then, as a result of that investigation, police went to your home, is that right?
yes,
And did they find in your home a substance that tested positive for methamphetamine?
yes,
Okay, and do you agree that you were in possession and control of that home and in that item?
yes,
Okay, Mr. Spencer, you satisfied with that factual basis?
I'm satisfied, Judge.
Ms. Goodrich?
Yes,
Okay, Mr. Stribic, at the time that this happened, you were on probation in our recovery court, is that correct?
Yes,
And part of the terms of your probation were that you not violate the law, is that correct?
yes,
And you agree that your conduct on that date violated your probation then?
yes,
And that as a result, you failed to comply with the terms and conditions of the recovery court program?
yes,
All right. And Mr. Spencer, I believe that does establish a factual basis for all 4 counts alleged in the probation violation in all the files. Do you agree, Mr. Spencer?
I do agree.
Ms. Curtis, do you agree?
yes,
All right, Mr. Spencer, are you aware of any other promises, threats, or inducements?
There are none.
Ms. Goodrich?
oh, yeah, no.
And Mr. Spencer, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes,
Ms. Goodrich?
Yes,
All right, Mr. Stribic, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of those offenses and have violated probation, so I do so find. We could schedule sentencing. Mr. Spencer, you available the morning of March 17th?
yes, Judge.
We could schedule this for sentencing on March 17th at 11:20 a.m. And we'll do an in-person writ, I imagine, from the Department of Corrections for that. Mr. Stribic, you have the right to be physically present in court for your sentencing. You want to be up here for that in person?
Depends on where I'm at. I mean, it doesn't really matter.
Okay, well, I mean, you've got the right to be here for sentencing, and if you want, that's not a problem at all. We'll do a writ and get you up here. Sometimes people who are already inside for reasons personal to themselves don't want to ride out, and they'd rather just go by video. So what we'll do is we'll do an in-person writ. If you decide you'd rather sit tight and do it by video, let Mr. Spencer know as soon as you make that decision so that he can let the prosecutor know so we can change the writ, okay?
Yeah, I can do that. I appreciate it.
Okay. All right, but otherwise on the new file and the probations, we'll do sentencing March 17th at 11:20 a.m. Anything further from the people?
Your Honor, we did receive a 180-day notice, just for the record, on January 30th. So that would expire July 29th, so we'd be within that time frame for something.
Okay. All right, thank you. Anything further from the defense?
Nothing further.
All right, Mr. Stribic, have a good day. Mr. Stribic, good day to you, and Mr. Spencer, good day to you as well.
Thank you.
All right. All right, we're going to call next People v. Kyle Kaniska, file 25-7065. Also, you want to state your appearances, please?
Melissa Goodrich, Flint County Prosecutor.
What am I doing? One sneaks up on me, the other one I think.
We got Mr. Gilbert for the defense. We're here for sentencing on OWI 3rd, 0 to 6. Charlevoix Recovery Court recommendation. Mr. Gilbert, any additions, corrections, or scoring challenges?
No, Kyle and I went through the pre-sentence report. I looked at the scoring. I have no challenges or corrections.
Any from the people?
There.
And this is a transfer out to Charlevoix, right?
That is correct.
And I have the memo of understanding. Looks like it's all been signed. Okay, anything you want to say, Mr. Kaniska's behalf?
Yes, Your Honor. In talking with Kyle, he's already been involved with the recovery court over there. I believe he's done it for a couple of weeks. And he really is telling me that he wants to embrace this. And as he knows that there's quite a bit hanging over his head. So I wish him the best of luck and ask the court to follow the recommendation.
Mr. Kaniska, anything you want to tell me today or no?
I just appreciate the opportunity to do it. And make the best of it.
Okay. Ms. Goodrich, any recommendations from the people?
I continue the recommendation of Charlevoix Recovery Court.
All right, well, Mr. Kaniska, this is, looks like a true third, but it was a very high BAC. And I think you got yourself even kind of worried about what was going on, that you ended up calling the police for some assistance. I think a treatment court is appropriate for you here. You've been accepted into the Charlevoix court. We've signed the documentation to transfer you over there. So this is the last time I'll see you on this case. If you violate, then the judge in Charlevoix County will impose a sentence. We're going to transfer the entire case over there. Okay. I'm going to place you on probation as recommended for 3 years, subject to the terms and conditions listed on pages 2 and 3 in the pre-sentence report. Chief among them are completing the Charlevoix County Recovery Court program. There's also fines and costs as ordered by Charlevoix. I'll follow their recommendations. $130 crime victims assessment, monthly supervision fee, $300 in court costs, $500 fine, $250 OUIL reimbursement, $60 DNA fee, $168 in state costs, $600 drug court fee, and $200 fine. It looks like it's $100 for the cost of prosecution, $100 to the arrest or agency fee. I'm not exactly sure how that sorts out, but that must be a Charlevoix thing. I don't have time to do that. But we'll impose those, and that's within the advisory guidelines. It's consistent with the plea agreement. Mr. Kaniska, if you want to appeal, you'd have to ask for a lawyer within 6 months. We're going to hand you a piece of paper explaining that process to you. Ask you to initial one copy for us. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, sir?
No, sir.
Okay, and that's, I guess, the probation order should probably only include the felony, I imagine. On the misdemeanor counts, it'll just be the fines and costs. All right, good luck to you, Mr. Kaniska.
Your Honor, currently he has a sober link. Is he required to still have that, or is that something he needs to address with Charlevoix?
You'd have to ask Charlevoix. I guess what I'll say is any bond orders that you have end today. So if you only use the sober link because of a bond condition,
yeah,
the bond condition ends right now.
Okay, thank you.
But whatever conditions of probation recovery court has on you, you follow those. Okay.
Okay.
So I would continue using it until you talk with your recovery court case manager.
Okay.